ERISA is a federal statute. It was enacted in 1974 to protect employee benefits. Employers often provide benefits to their employees, things like disability insurance, life insurance, health insurance, pensions. Those types of benefits are governed by this federal law called ERISA. Because ERISA was meant and designed to protect employees and their benefits, there are a lot of regulations in place now that require insurance companies to give things like a full and fair review, to make sure that they give proper reasons for denials, that they follow the plan documents, that they make sure they don't misrepresent things, that they are fiduciaries and act in any fiduciary capacity. But a lot of times what we see is that doesn't happen. That insurance companies all too often want to deny, especially disability claims, but life insurance claims, accidental death claims, even pensions. And that's when you need to come to us and we will evaluate what they did wrong, how they might have violated the regulations, or how they might have violated their breached their fiduciary duties because of the way that they handled the claim. If your ERISA insurance claim is denied, by law, you have at least one right to appeal that decision. If you do have an appeal that needs to be prosecuted, you should immediately contact a law firm, and I would urge you to contact McKinnon Law Group, because you're going to want to make sure that the appeal is prosecuted correctly. If you don't do it right, you may be prejudiced, and you may prejudice yourself in litigation, because what happens is when you file an appeal, there is what is known as an administrative record that is created, and because of that administrative record, the insurance company either accepts or denies the claim based on that. And when we put it into litigation, we are limited typically to that administrative record. There are some exceptions to that, but normally we're going to be limited. If you don't hire an attorney like McKinnon Law Group, you might not get all the records that you need to get in. So we need to make sure we have personal statements. We need to make sure we have good doctor support, medical records support, doctor certifications that are well written and compelling. If we need to hire an expert, we get expert reports. And we make sure that your appeal is appropriately done so that that administrative record is in the best place it can be for litigation. As contrasted with non-ERISA claims, where there are more types of damages available, ERISA is more limited. First and foremost, whatever the damages are under the contract. So if it's a disability policy, then it's the disability benefits. It might be payable every month for 20 years. It might be payable till age 65 or age 67, depending on the terms of the long-term disability contract. If it's a life insurance policy and it's a denied claim and you have a death benefit of $250,000, it's going to be that $250,000. In addition, there's going to be interest that we can get on the amount of money that you should have been paid but weren't paid. In addition, we can get costs. And probably most importantly, after getting all of the benefits, we can get attorney's fees. I have 36 years of experience handling ERISA cases. 24 of those years were spent representing insurance companies. The last 12 of which I switched sides and I started representing plaintiffs because that's really where my heart was. So we have significant experience, but not only just on the plaintiff side, but also on the defense side. So we know both sides. When a client communicates with us, either by email or telephone, it is very important for us to get back to them. We understand that they're nervous about their cases, they have questions. We're there to answer those questions, and we do it well and we do it quickly. So I pride myself and my firm on our ability to get back to people. Our standard is to try to get back to everyone within 24 hours of the date of the email or the phone call. Communication is essential between our clients and ourselves, and so we strive to make that a very important part of our representation. We are a small firm, and because we're a small firm, we're agile. We can make sure that we get things done quickly. We don't have levels of regulatory detail to go through with bigger firms. A lot of times, if you have a decision that needs to be made on a case or whether to take a client, it has to go through a panel, it has to go through higher ups at the law firm. I make those decisions, I make them right away. And because I don't have to answer to anyone else, I can take more risks if I need to on behalf of my clients. And that will inure to their benefit because we normally will get a better result. When you hire my firm, I stay involved with your case. I stay involved with every case in the law firm. However, what I do is I will give the case for day-to-day handling to one of my attorneys. However, I'm there all the time. I'm able to answer any questions that you have. I am able to make sure that everything is done well. I supervise all of my cases and all of my attorneys. When you come to us initially about your ERISA claim, we'll listen to you as you describe your claim. We'll get all the facts, we'll answer questions, and we'll decide whether or not we think you have a good claim. So the initial evaluation process begins right away. And that process is going to continue. So after you sign a fee agreement with us, you sign authorization forms, we go to your employer, we go to the insurance company, and we get all the documents we need. We get the plan documents, ERISA plan documents, we get the ERISA policies, the insurance policies. We will also get the claim file. So in ERISA, it's known as the administrative record. We evaluate those records, and then we call our clients and we have a discussion with them about their claims. And we develop a plan of action. We'll ask them questions and answer their questions. And then through that process, we conduct this evaluation. And then we move forward. And the evaluation continues throughout the whole case because things are always changing. But the process of evaluating the case is the process that begins at the very first communication we have with you, all the way through the case until it's resolved.